Let's take a look at question 4 on the February 2024 California bar exam. It's a long hypothetical. And so I see at the bottom of the page that the question continues on the next page. Call 1. Did the court properly deny Dan's motion to suppress the photograph? Motion to suppress, probably criminal procedure. It's a D name on the California bar. That flags the fact that Dan is a defendant. So I would assume this is a criminal case. Dan has filed a motion to suppress a piece of evidence. Crim pro. What do we have for the rest of the calls? I see a second call with 3 parts. Assuming all reasonable objections were timely made, did the court properly admit under the California Evidence Code? So this is crim pro crossed with California evidence. And how do you know the whole thing isn't California evidence? That under the California Evidence Code modifies only the second call. So you can be sure the first call is crim pro. So the A piece of evidence is Tessa's testimony about her statement to the defense investigator. That T name doesn't help me. If it were a W name, I'd be pretty sure this is a witness. It's not the prosecution, it's not the defense, so I'm not sure who Tessa is. We're going to have to get to the hypothetical to figure that one out. But I can tell just from this that it's hearsay. She's testifying about her statement out of court to a defense investigator. Okay, the B call is the photograph with Tessa's signature. And the C call is about ATM records. It sounds like both of those involve documents, maybe secondary evidence rule. We'll have to look at the hypothetical to figure that out. The secondary evidence rule is what California calls the best evidence rule under the Fed system. The reason I say call B is probably involving the secondary evidence rule is because it has Tessa's signature on it. So if that is at all at issue, it's going to be secondary evidence rule. Now, when they give you California evidence, the very first thing you want to address is Prop 8, which under California made virtually all evidence in a criminal proceeding, all relevant evidence is admissible. No relevant evidence shall be excluded unless it's barred by 352 hearsay, privilege, rape shield, or special character evidence rules. And you're going to want to get that preliminary statement out there right away because this is a criminal case and it's California evidence. If you need help with California evidence, you can consider subscribing to our Patreon channel. We've placed our review of the differences, the major differences between California evidence and the federal code there. The link is below. So what do we have here? Acme Bank was robbed in December 2022. On January 15, 2023, Dan was charged with robbing bank. In April 2023, Officer Pat showed Tessa, the teller who was robbed, photographs of 6 men, each of whom were the same race, approximate age, and had blonde hair and a mustache like Dan. Tessa immediately selected the photograph of Dan, saying he was the robber, and signed her name on it. That's the photograph in call B, the photograph with Tessa's signature. Before trial, in the Superior Court, Dan moved to suppress the photograph under the 6th Amendment to the United States Constitution, claiming that it should be suppressed because his attorney was not present when Tessa was shown the photographs. The motion was denied. That goes to call 1. Call 1 says, did the court properly deny Dan's motion to suppress the photograph? Sixth Amendment, that has issues involving right to counsel and involving pretrial identification, and I think both of them are raised here. So let's go take a look at the law. Okay, we're in proponics. I need to get to criminal procedure, and within that, to Sixth Amendment, because that's the basis of his motion to suppress. Sixth Amendment has a lot of issues, but I think the two involved here are right to counsel and pretrial identifications. Let's look at pretrial identifications, and we see that right to counsel under the Sixth Amendment is implicated here. So let's take a look at that. It attaches after formal charges are brought, so it applies at post-charge lineups, and that's where we are. We're at a post-charge lineup, but it does not apply to photo showings, and this is a photo showing. Okay, then he does not have a right to have his attorney present during a photo showing. But the second issue we had there was about denial of due process. And that is a big one here because they gave us a lot of facts to show us that there was no denial of due process. All blonde men, all with mustaches. I need to talk about that too. But that's not all I want to talk about. I want to talk about the right to counsel because the issue is, did he have one at all? So let's look at that. And we see that the Sixth Amendment right to assistance of counsel applies to all felony prosecutions. This is a felony prosecution. And to any sentence that might result in any actual loss of liberty. Okay, we have a felony prosecution, so he does have a Sixth Amendment right to counsel. The next question is, are we at a stage where the right has attached? It attaches only at critical stages. In adversarial preliminary hearings, in post-indictment interrogation, or after an accusation in writing by the grand jury, in a post-indictment lineup, in an arraignment where the accused is brought into court, at the plea stage, at sentencing. He had a right to counsel, but we know that that right doesn't apply to a photo showing. So in Call 1, I'm going to want to explain the Sixth Amendment right to counsel, that the right does apply to him because it's a felony charge, that he is at a critical stage where the right would attach. Then I'm going to want to explain about pretrial identifications and the fact that although there is a Sixth Amendment right to counsel, it's not for photo showings. Okay, now, at trial, the parties stipulated that the photograph Tessa had selected was neither a business record nor an official record, which I need to note because Call 2B is about the photograph with Tessa's signature, and I'm being told here that I cannot use business record or official record to get that photograph in as exceptions to the hearsay rule. The prosecutor called Tessa, who in court identified Dan as the robber. Now, I believe that's telling me that she made an in-court identification of the defendant himself. She's not looking at the photograph. She's identifying Dan. On cross-examination, defense counsel asked Tessa whether she had made a statement to the defense investigator in February 2023 that the robber had black hair and no mustache. Tessa admitted to having made the statement but testified that it was incorrect because the robber did have blonde hair and a mustache. This is impeachment. California differs from the Fed in some crucial ways, and we need to take a look at that law. Back to proponics. We need to go to California evidence. There we go. This is a prior inconsistent statement being used to impeach this witness. So I'm going to go to hearsay because this is an out-of-court statement with which she's being impeached, I'm going to exceptions to prior statements. She is a trial witness subject to cross. So what do we have here? Prior inconsistent statement. It's accepted from the hearsay ban if it's inconsistent with the declarant's in-court testimony and the declarant is given an opportunity to explain or deny the prior statement. The prior statement does not have to have been under oath. That's contra to the federal rule, where for prior inconsistent statement, it has to have been made under oath. So I know the photograph with Tessa's signature is also at issue. That's a prior identification. That's called 2B. So look at that one. The identification of a party or other person who committed a crime. It was made at the time the crime or other occurrence was still fresh in the identifier's mind, and she must first certify that the identification made was a true reflection of her opinion. We may have a problem with that second element. At a time it was fresh in her mind. The robbery was in December. It wasn't until April that she was shown the photograph and identified him. Is that still fresh in her mind? So that's going to go to call 2B, which is next in the facts. On redirect, Tessa again identified the photograph of Dan as the robber. This was the same photograph Tessa had signed previously. The photograph was admitted into evidence. So this is a witness who has just been impeached using a prior inconsistent statement. The prosecutor now wants to get in this photograph, which you could view as a prior consistent statement. So recall what we saw you need for a prior consistent statement. If the declarant has been attacked with a prior inconsistent statement, and that's exactly what happened here. Defense counsel attacked her credibility by getting her to acknowledge that she had made a prior inconsistent statement. So now prosecution is attempting to rehabilitate using a prior consistent statement with the signature on that photograph. That might solve our problem in that a prior identification is difficult because it wasn't made at the time the crime happened. It wasn't fresh in her mind. It was months later. But look at what the author of this hypothetical created here. He gave you defense counsel trying to admit a hearsay statement that he's using for impeachment purposes. So as impeachment, it would be non-hearsay. But it's also a prior inconsistent statement, so you can show that you know the elements of that. Then the prosecution is going to try to rehabilitate using prior consistent statement. That'll work. Prior identification probably won't. But you get to show your knowledge of the elements of every one of those three prior statements. And of course, for each piece of evidence, you're going to want to analyze logical relevance and remember that you have to include disputed fact in California. We have what we need for calls 2A and 2B. And since that photograph is being admitted into evidence, I need to address the best evidence rule, which in California is called the secondary evidence rule. It is the original photograph with her signature, so the issue is, was it properly authenticated? The facts are silent about that. You'd want to discuss that in your answer to call 2B. And that brings us to call 2C about the ATM records. So now we see in the defense case, Dan testified that he was not the robber and that he had been visiting his mother in Alaska for 3 weeks, including 1 week before and 2 weeks after the robbery. In rebuttal, the prosecutor called Chet, the custodian of records from Credco, a credit union. Chet identified records from a Credco automated teller machine located down the street from bank. Chet testified that the ATM records were created as part of Credco's regular course of business. Chet further testified that the records reflect a withdrawal was made from Dan's account the day before the robbery using a personal identification number assigned to Dan's account. So what they've given us there is another document, a record. So we have to address the secondary evidence rule, and here we're given clear authentication from a person who knows. So authentication isn't a big issue. I need to address it, but it's easy to resolve. Hearsay is a big issue, and how am I going to get this one in? I'm going to get it in as a business record. They've given me all the elements of the business record exception right here in the facts. So what else do I need to address on this one? Well, I think 352. I haven't addressed that yet in my answer, and I need to get it in here somewhere, and this seems like a good place. You could have done it in one of the other calls. It wouldn't matter as long as you get a 352 analysis in there. 352 is substantially the same as Rule 403 in the FRE. Here the probative value is high. The risk of unfair prejudice seems pretty low. It's something that the defense can address if they believe someone else used his PIN or somehow his account was hacked. Okay, we've been through the entire hypothetical. Go back to the calls and let's sum up. First of all, because it's a criminal case, I would explain Prop 8. Then, on call 1, the crim pro call, I'd cover Sixth Amendment. I would cover the fact that he had a right to counsel because this is the kind of case that affords a right to counsel. He had reached a critical stage, so that right had attached, but there is no right to have an attorney present during a photo showing. The other portion of the Sixth Amendment that we need to deal with is the issue of fairness, due process. So use all those facts about what the photographs were like to demonstrate that there was no due process violation here. So the court properly denied the motion to suppress the photograph. Then we move on to the second call, the California evidence call. And of course, I want to start with logical relevance for each of these pieces of evidence and analyze logical relevance, remembering that California requires for logical relevance that it's a disputed fact of consequence. In the A call, we have a testifying witness on the stand, and the defense wants to bring in a statement that witness made in the past that's inconsistent with what she's testifying now. So the logical relevance is to impeach the witness to show that she is not credible. Is it being offered for its truth? Or is it simply being offered to show that she made an inconsistent statement in the past? That would mean that it goes to her character for truthfulness and it's non-hearsay. But if the defense is trying to use it to show that the defendant is not the robber, that she spoke the truth in the prior statement, then it would be hearsay, and we would be using prior inconsistent statement to get it in. That is a key area where California differs from the federal rules. The prior inconsistent statement need not be under oath under the California code. It would have to have been under the Fed. So in California evidence, it comes in. In the Fed, it does not. Now, if you have time to briefly analyze any other way out of the hearsay rule, then do so right here. Call 2B, the photograph with Tessa's signature. If the contents of a writing are at issue, in other words, the signature, then the secondary evidence rule is applicable, which means it has to be authenticated and we have to find a way out of the hearsay rule. We don't have facts to show that it was properly authenticated, so you have to analyze that. As to a way out of the hearsay rule, it was stipulated that this is neither an official record nor a business record. But this is the prosecution's attempt to rehabilitate this witness. So think about prior consistent statement and prior identification. And those two need to be analyzed. And I would point out that both of those differ from the Fed. So for prior consistent statement, the California Code allows that for rehabilitation if the witness has been impeached with a prior inconsistent statement. The Federal Rules of Evidence, is more restrictive. They allow it only to rebut express or implied charges of recent fabrication or improper influence. And so it would be harder to meet that under the federal rule. But in California, it's working. What about statement of identification, a prior identification of this defendant? There, California is more restrictive than the federal rules. In California, you have to show that the statement was made at a time when the crime or other occurrence was fresh in the declarant's memory. And that's a problem because she was shown that photograph 4 months after the robbery. What about call C, the ATM records? Again, we have the secondary evidence rule as a problem. If you've already thoroughly analyzed that in the B call, then simply refer back to it and discuss any way in which this is different. Obvious way is that we know that this was thoroughly authenticated. We have the custodian of records on the stand for this piece of evidence. It's being used to impeach the defendant who has already testified. It's hearsay, and we have to get out of the hearsay ban in order to get this in. The way we can do that is through one of the documentary exceptions, the business record exception, and they give you all the facts you need to meet the elements for business record exception. Would I try another exception? Yeah, that's always a good idea in California because in large part it's an issue spotting exam. So if you can try a second way out of the hearsay rule, always do that, assuming you have enough time to finish the essay. But I also need to do a 352 analysis, the equivalent of an FRE 403 analysis. I need to look at the risk of unfair prejudice and opposing that the probative value of this piece of evidence. All of these are racehorse essays.